You started, Mr. Mupon, by saying that you did think that there were as-applied equal protection challenges and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no a valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom are a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup would come in and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3 of men.
But why